My name is Virgil Flores, founder and CEO of Legal Services of America. I'm coming to you today from our home offices here in Rancho Murieta, California. I want to thank you all for taking time to review this valuable information regarding our risk management systems for buyers and sellers, as well as their real estate brokers and agents. I should first start by telling you that realtors are the second most sued industry in California, second only to doctors, and that out of all the lawsuits filed in the United States, over 50% are filed here in California. These frivolous nuisance lawsuits that plague our industry are very costly in the way of legal fees. Most attorneys charge $7.50 an hour, increased cost of the E&O insurance, higher and higher E&O deductibles, and most expensive of all is the loss of time and lost productivity to the agent. The California Association of Realtors recently stated that a real estate agent will lose 3 months of productivity dealing with one of these matters. I've spoken to some realtors who have told me that it takes sometimes a year out of their lives. Our company's track record is we will stop 97% of any threat of lawsuit against our client from ever reaching their errors and omissions insurance. The way that we do that is by engaging all parties to the transaction in a risk management system that doesn't allow these matters to immediately gravitate to a lawsuit. We saw too many times that the real estate agent was being asked to give legal advice, which we know is against the NAR Code of Ethics, Article 13. So now when your buyer or seller has a legal question that could impede or delay or even destroy the transaction, they'll be assigned a real estate attorney that's versed in that area of law, and they can have as many legal questions as they need answered and have as many documents reviewed to help them and you close the transaction legally, tight, and right. After the close of escrow, we're giving your buyers and sellers lifetime mediation and a dispute resolution system effective at wringing the anger out of the problem and getting buyers and sellers to work out their own differences without expensive litigation, and especially without involving the real estate agent. These services satisfy the clause in the residential purchase agreement that directs them to mediate before they litigate. Let me offer you just a few examples of the type of legal questions we get in our office every day. The seller needs legal advice to determine if he can legally turn down a lower offer that came in first for a second higher offer. Sellers having problems with tenant allowing access to the home for showings. Buyer would like to discuss an agreement between the seller and the neighbor regarding a structure the seller allowed the neighbor to build and whether the buyer will have any rights to ask the neighbor to tear it down. Sellers threatening buyer with relisting the property if they do not move forward with the transaction. Buyer needs legal advice to find out if seller would be in breach of contract for relisting without cancellation. Sellers having problems with evicting tenants. They are asking for relocation costs to move. Seller needs legal advice regarding the tenant's demands. Buyer needs legal advice regarding a document her ex-husband sent her to sign on a property they both owned and have since sold. Buyer would like advice regarding failure to disclose and his rights. After the close of escrow, the buyer discovered a leak that caused damage to the walls, ceilings, and windows. The homeowners association completed partial repairs, but is not taking full responsibility. Buyer is considering suing the homeowners association in small claims court for reimbursement of her costs. After the close of escrow, buyer discovered a gas leak that the seller had paid to repair. The repair that the seller paid for was faulty, and the buyer had to hire another company to come out and properly repair the leak. Buyer would like to be reimbursed by seller for repair costs. Our services are typically paid for by the buyer or seller from the proceeds of the transaction through escrow. and they're only paid when there's a successful closing. If there is no closing, there is no fee. Some of my clients have come to me reporting that these valuable added benefits are what made the difference between them getting the listing versus their competition. So as part of your membership, you'll be receiving flyers and postcards that you can customize to use in your marketing and at your next listing presentation. Now let me go into the real estate risk management services for the brokers and agents. When the real estate agent or broker is faced with any sort of threat of lawsuit, be it a demand for money or request for mediation or an actual summons and complaint, our company, Legal Services of America, will agree to pay your real estate attorney to provide legal services to vigorously defend you, the realtor, against all allegations. Our list of benefits include telephone consultation with the real estate attorney, in-office consultation, and a review of any documents pertaining to that legal matter. At that point, our attorney will agree to write 3 letters on your behalf. These cease and desist letters will clearly explain to the adverse party that you are part of a group legal service plan and that your legal fees and errors and omissions deductible have already been paid for by thousands of other realtors in 3 states. If the problem is a small claims court matter, we will pay for an attorney to prepare the agent for court, and if needed, we will pay the attorney to appeal the matter. As part of our services to the real estate agent, we provide commission collection in the case where the seller is refusing to pay the agent's commission. If the matter goes to mediation, we will pay the real estate attorney to represent you. We provide Department of Real Estate defense for any accusation or filed complaint, including a hearing, and will represent you to a Board of Realtor hearing, mediation, or arbitration. If you need the attorney for any other non-covered services, they'll agree to reduce their hourly fee by up to 25%. I've said to you, if the problem results in a claim against your E&O policy, our company will agree to cover the errors and omissions insurance deductible. And lastly, for some companies, we are also able to cover all of their past transactions. The services are paid for by the buyer and seller at the successful close of the transaction. And even though your clients may have used the service multiple times, if there is no close, there is no fee. We propose that your company agree to place our fee on every one of your future closed transactions. If for some reason the buyer or seller would not agree to pay our modest fee, we would ask that the agent pay to protect themselves and to provide a valuable closing gift to their client. If you have further need for information, I'd like to invite you to go to our website, www.legalservicesofamerica.com, to review our client testimonials and our excellent Better Business Bureau ratings. Feel free to call me directly at 916-203-1989, and I'll be happy to schedule a Zoom presentation for all of your agents. Thank you.